Good afternoon, everyone. Thank you for joining us for the litigation section. I'd like to briefly introduce you to our speakers today. Today we have Mr. Michael Gatto. He's a former prosecutor and has tried over 100 jury trials. He owns and manages his own firm, Law Office of Michael E. Gatto, PC, located in Walnut Creek. Michael specializes in involving complex legal and medical issues and accepts catastrophic injury cases on a referral basis. He's handled matters involving everything from medical malpractice, skilled nursing facilities, product liability, premises liability, exceptions to workers' compensation, motor vehicle and trucking accident matters, and general negligence and intentional torts. Michael uses his extensive knowledge of medicine to obtain favorable resolutions for his clients by effectively communicating complex medical issues to mediators, judges, and, when necessary, jurors. He holds the record for the largest medical malpractice verdict in Contra Costa County. Michael appeared as himself in the documentary, The Giant Peas, that is the Global Economy, Episode 6, the death episode on Amazon Prime. Michael discussed how governments and businesses assess risk associated with expected carnage from their activities. He is a member of the CAOC, AAJ, Alameda Contra Costa Trial Association. He was the past president in 2018 and Western Trial Lawyers Association. He's admitted to practice in California and Arizona. Today, we also have Dr. Benjamin T. Busfield. He's a diplomat of the American Board of Orthopedic Surgery, fellow of the American Academy of Orthopedic Surgery, Diablo Orthopedic Consultants, Inc., CEO. Dr. Busfield is an East Bay native and an expert orthopedic surgeon with 17 years of legal consulting experience. He is double board certified surgeon in sports medicine and orthopedic surgery and in active practice with a legal consulting interest. His offices are in Walnut Creek and Antioch. He has 15 peer-reviewed publications. Dr. Busfield gives an objective opinion in every case and does not favor defense or plaintiff. The goal is to provide an objective case review, avoid frivolous lawsuits and wasted resources, and convey an understanding of the strengths and weaknesses of each case. Dr. Busfield sees patients through certain insurance plans, often offer care on a lien, and enjoys expert consulting and IME work. He's board certified in orthopedic surgery and sports medicine. He's a fellow of the AAOS, ACS. He is available for immediate cell phone access for cases. He offers rapid initial review and expert reports for any deadline. He has a wide spectrum of practice interests, allowing expert opinions on nearly all injuries in multiple injury patients. He has legal expertise, including product liability, malpractice, personal injury, and liens.
Let's get you something. Thank you.
Thank you so much.
Thank you for coming.
Thank you. I appreciate it.
So this topic is a civil case, soup to nuts. We're going to talk about cross-examination, opening statements, introduction of medical testimony, and also use of videotape depositions. Some of you I know, and some of this is geared towards younger practitioners, middle experienced practitioners, but I know Judge Flyer, I know Malcolm Schur, a noted mediator. How many of you do Plaintiff personal injury claims. All right. Yeah. And then how about defending them? All right. Well, my general goal when I'm speaking, I speak typically a half a dozen or so times a year, is to provide my audience nuggets or takeaways, things that you can use in your practice today or in the very near term. So despite the fact that we've got a retired judge and a mediator here, hopefully some of these things, a couple of them, hopefully there will be some interesting food for thought and we can have a nice dialogue here. So the first thing we're going to talk about is cross-examination. The real simplistic thing is, hey, all leading questions. Well, this discussion assumes everybody knows that, and this discussion is sort of more along the lines of advanced cross-examination techniques. As Patricia pointed out, I've tried over 100 jury trials. I tried over 150 bench trials. When I started as a prosecutor, I was taking testimony and cross-examining witnesses every day, sometimes many in a day, many hearings. So we had detention hearings, probation hearings, motions to suppress, sentencing hearings, and of course trials. And the skills that I necessarily developed and some techniques that I came up with and then hopefully refined, I'm going to suggest and posit here today, and hopefully some of these will be things you may want to use and incorporate. Sometimes they work very well for me, sometimes not so much, but they are sort of high risk, high reward. So we talk about, before we get to the cross-examination, the absolute sort of nuts and bolts of a case. Initial considerations, we talk about our intake process. And this is very much from the plaintiff perspective. I'm going to weave in the defense perspective as well. But for my intakes, I basically have two. One is medical malpractice, the rest is everything else. And I have a series of questions, a flow path, and if we have a no, that is the end, okay? We need to be respectful, considerate. I probably reject half a dozen death cases a week. So the emotional investment of talking to these people is really tough, and I try to limit it. I also try to be cognizant of the toll on my staff as well when they're doing these intakes. But this is how we sort of engage in the intake process. It's a flow path. When we get to the investigation, what tools do we have? What's at our disposal generally? We get traffic collision reports. Sometimes we'll get incident reports. Often these are going to be privileged and you will have a fight. But sometimes the person that did the incident report isn't your target. You can get around it and obtain access. Regardless of whether or not it is privileged, the identity of the witnesses cannot be withheld. I had a case some years ago. It was a fall at the Martinez Amtrak, and the woman had been referred to me. So I went out there. She was in her late 70s. Her son was a contractor, and she was telling us in advance what had happened. And then as we got out there, she was walking around trying to show us where it was. They brought the medical records with them and met them there, and she was trying to show us things. It was a very cute relationship between this like 79-year-old woman and this 53-year-old guy, and they were teasing and bantering back and forth, but she was convinced that there was some construction and she had fallen. There was no construction. There was no fresh cement. The son knew. He's like, Mom, no, this isn't happening. I start reading through the records, and I see that she fell getting off the train. I don't know how to reconcile this, but I'm thinking it's not a case. I talked to them. Amtrak had written to this woman a couple times, offering to settle. And these weren't your general offer to settle letters where it's like, hey, they'll always pay a couple grand to close down this file. So I told the son, I said, look, Mom had a very serious injury, horrific humeral fracture, surgery. Let me see if maybe they'll entertain a demand and we won't have to litigate. I talked to them and I say, this is going to be big, right? If you don't want to do this, tell me now and we'll file. but if you're interested, I'll give you a fully documented demand when she's better. I said, okay. I did all kinds of research on this Amtrak. They had been sued before. They had horrible ADA violations associated with this. And I found out all the protocols relative to Amtrak and their treatment of elderly passengers, and the fact basically that they're to have ushers getting them on and off. So I used all these protocols. I had all kinds of great evidence. I just didn't know how the woman fell and was hurt, but I knew Amtrak wanted to settle. So I knew Amtrak's internal investigation was negative for them. So we started negotiating, and I'm talking to this pleasant woman in DC, and we're going back and forth. And she said, you know, nice demand, sad and all this, but you don't say how she fell. I filibustered. She asked me again, you don't say how she fell. I filibustered. She said it again. I said, look, I don't know how she fell. You do. You know I'm going to find out in litigation. Let's stop talking about it. Let's talk about money and get it done. And we did. All right? Never figured out how she fell.
Touche.
But, next thing, once we get incident report, find out defendants, 99% of my cases settle with insurance money. Generally, it's a function of policy limits. There's yet another discussion that I have on working with coverage counsel. I work with Demi and Oxenendler, a tremendous coverage lawyer, about getting coverage, getting around coverage, getting excess coverage, things of that nature. But we always need to find out the policy limits. We got to work out damages. We have to figure out a source of recovery beyond policies. Is it an underinsured, well-funded, highly successful business like I'm suing right now? Is it a crazy wealthy homeowner in Black Hawk that stabbed one of his neighbors, for which you would presume there's no insurance? He was convicted of aggravated assault. That's an intentional tort. He wouldn't cooperate with the insurance company. That's another basis of exclusion. I got the insurance company to pay on that case. The theory we ran was that his spouse knew he was a drunk, knew he was an angry drunk, knew he had animus towards this neighbor, knew he was armed, knew he was going out that direction, and she didn't warn. And it was enough to get this insurance company to cough up their policy. We then turned to the homeowner. I told his lawyer, we'll give the guy a life estate because he's going to die soon. He can stay in his house, but he's going to give the money to my client. He thought that was very interesting. He didn't go along with it, but he's like, where do you go with this stuff? I said, that's how I make money. That's what I do. We ended up getting a pretty significant contribution. I wanted more. My clients wanted to shut it down, but we did. Okay. Health insurer liens. These are a massive problem. You mediators know and recognize that they are a huge obstacle to settlement. Self-funded ERISA plans, they say they get the first dollar, every dollar your firstborn, everything you've ever seen, owned, will ever amass. Okay? I call these people, I tell them, I'm not a collection agency for you people. If you're not going to play ball and put it in writing now, I'm going to tell my client to walk away. I've never had one of them not play ball. I also hire Synergy, an outstanding outfit that is highly successful in doing these, and they will work after I work, and they only take a percentage of what they save. So they are phenomenal resources for plaintiffs, for plaintiff attorneys. I also will enlist Medi-Cal, Medicare, big lien holders to get them on the phone at mediation with the mediator. I speak with the mediator in advance. I work it all up, and I say we all have to work together to get to yes, or it's not going to happen. Okay? We also do this in the work comp arena. Yet another article I've written, wiping out comp liens for employer fault. We foist the problem of the future care off of the tortfeasor, off of work comp, and onto the federal government via an MSA. Again, we have Synergy underwrite the thing and figure out how much needs to be parked in an MSA. There's no law right now requiring MSAs in personal injury claims. They only exist for work comp. Prudent top plaintiff attorneys are using them now. in abundance of caution if the law is to change and apply retroactively. So again, there are resources out here. But if you work on these things up front, you get an agreement for them to play ball, you get them to the table at mediation, you have a highly skilled and motivated mediator that can leverage them. I've done these on sliding scales where I say, look, if my recovery is X, you'll get a certain percentage. You have to bring these things together to get to yes. The next huge consideration for me initially is venue, okay? We have some exceedingly conservative counties in California. You may have a choice between venues. I have a med-mal case I'm prosecuting now in Solano County. And there's really only 2 hospitals in the county, so if you're a judge, you're either going to Kaiser or North Bay. They both suck, but you got not a lot of choices and the judges are going there. I'm going after North Bay in this particular case. I don't really want to be in Solano County against North Bay as bad as they are. So I do research, and one of the negligent doctors lives in Alameda. So I file in Alameda. Defense attorney calls me up, he says, you're in the wrong county. I said, check with your client where she lives. Calls me back a little bit later, tells me she doesn't reside in that house, and if you look at CCP, I think it's like 395, I forget which one it is, all they need to do is do a declaration. She did not reside in that house any longer. She had moved out, she had a different address. So now he tells me, you gotta move the case. I think, well, wait. So I pondered a bit. I said, okay, let me tell you what, I'm gonna cut you a deal. The deal is, I won't ask your client for a penny in settlement while we're in Alameda. So if we get the case resolved, you're golden, right? Will you do it? I don't know. Got to talk with the insurer, got to see. Calls me back, and they say, yes, they'll do it. So what did that tell me? I infer that that doctor and that carrier were worried about their liability. Because otherwise they wouldn't have cut the deal. They just said, screw off. Well, case ends up getting mushed to Solano County anyways. But now, I'm pretty confident that that doc and that insurance company are still sweating this. We're set for trial in June. You see me in July, August. If it's not confidential, I'll tell you how it played out. But it's an interesting consideration when you have multiple defendants or you have a defendant that has multiple places of business if you can pick your county. Had a case some years ago, a peace officer involved in 3 motor vehicle collisions in about an 11-month span, all rear-enders. 2 in Contra Costa County, 1 on 24, 1 on 680. 1, she had parked in front of the Alameda courthouse. She was just gathering her stuff when somebody else was parallel parking and might have bumped her at like a mile or 2 per hour. There's a rule, because she's on duty, that she has to report the property damage. And so we get all this information. The responsible party is uninsured, but it gave us venue in Alameda. We got a great jury pool, we got a great judge, and we got a massive settlement, and that thing probably would have been worth 20 to 30% less if we were in Contra Costa County.
How would you rank the Bay Area counties in terms of plaintiff desirability, beginning with number 1?
I think Alameda is very high on the list. San Francisco is changing dramatically. I've seen a pretty dramatic change in Contra Costa County. I tried a case in Contra Costa County in '99. We went through a couple hundred jurors. Tried a case in Contra Costa County in 2012. Probably had about 60 to 80 jurors, and then a case in Contra Costa County in 2014, and we went through about 100. It was against the county, so it was a big deal. A lot of people were getting struck for cause. Solano's very conservative. Sonoma is a drag, and Sonoma's a big problem because of their trial schedule. So the days of the week and the hours of the day, so the cases that could be done quickly drag, so that's a big problem. Napa, I don't know the jury veneer per se, but the judges are pretty conservative. Not a huge fan of San Mateo, not a huge fan of Santa Clara.
Right.
Marin, oddly, I've only had a couple cases out of Marin County in my entire career. And one of them was massive, but we never got close to the courthouse steps. I don't know. I'm also a big fan of focus groups. I'm a big fan. I have a woman now that's like Clarice Starling. She's amazing. She was literally an FBI profiler, worked on the B2K killer stuff. She's the woman I don't ever want to go to trial without her next to me. Really amazing. So I think that our demographics are changing. And I also think it's very clear AAJ has put some stuff out. Verdicts are going up. We don't know exactly what to attribute it to, but it is not subject to debate in terms of the numbers that are coming out now for what seemingly before was inconsequential injuries. Nick Rowley is a phenomenal trial lawyer. He has espoused a great number of radical theories that have been adopted and used successfully. But I believe that even in the most conservative counties, real damages will get big numbers. The defense will dispute it, and you show them one and they say, well, that was aberrant. They spin everything, but numbers are getting a lot better. I don't think it's subject to debate. All right. In terms of informal investigation, you want to get out to the scene. You can even go to the defendant's place of business. I apologize, I don't have the site for this. I think it was one of Chris Dolan's cases. He went out to like a grocery store or some business that was open and was doing measurements and things like this and got some data. And I can't remember exactly how the MIL went down or if they sought to exclude the expert. They said, no, you're open for business. They can chase you out, they can kick you out, whatever they want to do. But you can go in there and do whatever you want to do until they kick you out. Private investigators, FOIA, and the internet. Having tried as many cases as I have, I think, a little different comfort with evidence than some people. So when I draft discovery, may choose not to send RPDs out in advance. The reason why is I believe it's malpractice to provide an adversary a document and not prepare your witness to answer questions about it. Well, I don't need the document in advance. I can ask the questions, get the document later, and beat them up about it. Ideally, I get the document surreptitiously. Kaiser protocols for medical malpractice cases are all over the internet. Listservs, I call my buddies and ask them if it's not under seal, if it's not protective order, if it's not confidential. I get the policies in advance. If I have an old case, there's a few frequent flyers, sadly, that I'm seeing, and I have the policies. I got a fall case right now. I wrote the demand. I had their fall policy because I sued them for a fall 2 years ago. So getting these things in advance and surreptitiously, not through the formal discovery process, tremendous asset. With FOIA requests, our government lawyers often don't know that you have the stuff. And so you can walk in, you have it, you didn't do anything improper, you don't have to give them notice, you do it even before the existence of the lawsuit, and during the pendency of the lawsuit, anybody can do a FOIA request. So we were trying a case a while ago in Madera County. It was a dangerous condition case, and one of the burdens under some case law is you have to show sort of the feasibility of the fix and what it would have cost. Well, I wasn't involved in any of the liability discovery. That hadn't been done. It was a potential directed verdict issue. There was a section of the road that we claimed needed a guardrail. We found out they put in a guardrail on the same road 3-5 miles down the road between the incident and trial. In the middle of trial, we had a PI send a FOIA request. We got all the data. We got the estimates and how they do them. It's like per foot, or it was some interval. That's how they quoted the price. So when I had their defense economist, we had already gotten this stuff into evidence, but I had their defense economist say, okay, yeah, they built that, was 2 miles long, yours is supposed to be 1.6 miles long, and they built it in this year, but we could back it up and tell you what it would have cost if they had built it 20 years ago when they should have. And we got all this into evidence through a FOIA request, and the attorneys didn't know it until we showed up and started asking questions about it. It was effectively pseudo-impeachment, it was new evidence, we didn't have any duty to disclose, we got it all in. But it was dangerous and rocky. But FOIA requests are a huge advantage. I have a case now that I'm working against Hayward Unified School District where we got a lot of stuff, but the adjuster knows. And they can't stop us from getting it, but she told us, we know you sent one, so since she said that she knows about the first one, I said, well, the second one's coming, because I read the first one and I learned a little bit, and now I've got some more questions. All right. The internet, tremendous resource, obviously, for a host of issues. Formal investigation, we talked about discovery, timing, follow-up. We're going to talk about depositions in great detail in a second. Site inspections, I talked about the Chris Dolan case. Site inspections are fascinating. I went out to a site inspection on a case, it's like a decade ago. International conglomerate owned a place. They had built an auditorium, and the auditorium was designed with continental seating. No center aisle. The road went all the way across. It was like 40 people. So to walk in, you had to shuffle for a long time. It was a pain in the ass. And the sides were ramped, and there's a preference for ramps because they're safer than steps, but it has to be the right slope. Too steep, you can't use ramps. Well, they didn't want the audience standing on a slope, so they made this sort of mishmash of perpendicular slots for the seats so the people could stand on it. But it wasn't a walkway, so the rise and run, the treads, none of that stuff matched. The international conglomerate found this unwieldy. They didn't like it, they weren't packing the place, and it took a long time for people to get in and out. So they said, screw it, we're just gonna rip 2 seats out of here. And now we got a walkway, it's a stairway under the law. None of the rise and runs and the treads fit and match. They don't sign it, they don't put lights in, any of that kind of stuff. We had a woman walking backwards to take a photograph in a place where she had previously taken a photograph. She fell on her coccyx, hit her head on the arm of one of those chairs, tore up her lumbar spine and her cervical spine. You guys think there's some comparative fault there? I think that one's on my website. I think we got $4.2 million for this. And we found all this out about the chairs and the stuff being ripped out because you could see the ones adjacent to the side were different than the ones that were finished on the aisle. And then you could see where the hardware was, and we asked them for photographs. They had tremendously ethical counsel. We had asked them for photographs. They couldn't find anything. And months later into this, they found a photo of the continental seating. And they gave it to us. We said, when did it get changed? They couldn't find anybody to answer. So I point this out because I've been to a few other site inspections, and it's imperative that you get multiple experts, you do a lot of thinking in advance, and you go in really open-minded. But they're a huge advantage, huge asset to take a look at under the code. All right. Questions at this point? Now we're going to talk, hopefully, something about more interesting is the cross-examination stuff. Reasons to cross-examine a witness. First is to advance your own case. Next, you can do this on liability, causation, and of course damages. Harm your adversary's case and impeach witnesses. Cross-examination provides you the opportunity to dramatically enhance your credibility through command of the information. Right? We're all told simple, quick, leading questions. I'm gonna ask you a series of questions, da-da-da yes, da-da-da true, da-da-da correct. If you fail to say yes or correct, I'm gonna shove this deposition transcript in an uncomfortable place. And so you want to, if you have the opportunity, impeach early, okay? Because once you educate the witness that they're gonna get cracked on the head if they say something other than yes or correct, damn, they will admit to anything. They'll admit they killed Kennedy. They weren't even alive when Kennedy got shot, okay? It is dramatic, it's really amazing. I stole that from Deborah Chang, I love her. All right, so you can impeach the witness or other witnesses. I tried a case some years ago. We stepped in on this case. So we didn't take many of the early depositions. We didn't depose the driver. The person that did was sort of mediocre, didn't ask a lot of good questions. He was a VP at Bally's. Right? You're not going to be allowed to be a VP at Bally's without a really big brain pan. This guy was prepped by a very good lawyer, so I was cross-examining him. I was making some points, but I wasn't getting really what I wanted necessarily. There were a couple issues that we knew would be contested. And when I saw the way this was playing out, I knew the next witness was the peace officer that had investigated the incident. And this gentleman was making a number of assertions that were not told to the peace officer. So, seeing the dynamic of the cross and where it was going, I said, okay, no more questions. Now I call my next witness, and although this was an item on my direct examination, instead of it being the fourth topic, it was the first topic. Officer Jackson, did Mr. So-and-so tell you A, B, C, D, E, F, G? None. Right? So I used that witness to impeach the defendant, and juxtaposing him in that fashion provided the maximum bang for the buck, right? Doing it later in the examination wasn't going to have the same value. And it was a tactical decision to make on the fly. It's why trial is so amazing. It's like an IV of adrenaline and steroids, right? I would pay to do a trial. It's like so exciting. I'm actually thinking at some point maybe I'll go be a volunteer DA. I just love doing trials. It was so awesome. All right, cross-examination and deposition. How many of you have heard or espoused the idea, save your best cross for trial? I was told that. I've heard people say that.
Yeah.
I don't buy into that. Ask a different question. How many of you, when you tried cases, tried 5% of your cases? That's probably me. How about 10? How about 15? How about 20? So I did this a couple other times in conferences. Some people got their hands up at 15. I don't think anybody did at 20. But at 15, I said, you may want to rethink exactly how you're doing stuff, because nationally it's only about 4%. But it doesn't matter what the number is. What I'm going to tell you now is what matters. If you're only trying 15% of your cases, that means 85% of the time, if you're saving your best cross, you're not getting any benefit out of it. Beat the shit out of them at deposition. Beat them into submission. Now, when I cut my teeth in the civil world, I was at Craddock, Camlin, and Conti. I had tried a bunch of cases. I didn't know anything about medicine. So when they would send me out there to do depositions, I would go crazy. I would ask everything under the sun. And I'm like, if this partner that's been doing medical malpractice for 20 years can't come up with stuff I haven't thought of, that's not my problem. That's his. So I asked all the questions. But I still do it because invariably now, I'll think of new stuff. And we get to test it with other people later. But you get so much out of it. And I cannot stress enough, defendants, most witnesses, videotape them because you get the opportunity to play it in opening. All right, so videotape all defendant and all defense expert depositions, cite the codes, and you can use these in opening statement. This is just the law on those points. For MCLE purposes, we can check a box that we got some code information. All right. cross-ray liability. How many of you guys have heard of ball on damages, reptile rules of the road? You guys read or heard of these books? I was trained up that these were the trilogy modernly as to how plaintiff attorneys are to try cases. Ball on damages, I'd say probably about 75% of it I knew in advance, largely intuitive. Probably about 15–20% of it was kind of like, damn, that's some next level, high level stuff. Rules of the Road is written by Rick Friedman, phenomenal trial attorney out of Washington State. And what he articulates basically is you've got to break things down to these fundamental premises that the defendant will either look like a total idiot for disagreeing with you, or they admit. I'm a huge fan of this binary concept. Door number 1 is bad, door number 2 is worse, okay? And you can kind of drive it in this fashion. Establish the defendant's knowledge of the risk of plaintiff's injuries for rules of the road. This presentation today is an amalgamation of about 4 presentations I've done, so you're going to see some repetition, because a lot of the presentations I'm doing now when I speak, which is usually about 6 to 8 times a year, they're knocking them down to about 15 minutes. But establish how easy it is to comply with the rules of the road, either through time, cost, or effort. I told you about that continental seating and the makeshift stairwell that they created. We had a human factors guy, this guy Cohen out of San Diego, who's the #1 or #2 in the world, depending on how you looked at it. We had an accident recon biomech guy, actually wasn't all that enamored of him, but impeccable credentials. We had a design architect. We had all these egghead genius people. But what were we talking about? It was so simple. So we looked at the yellow pages and we hired a ham and egg contractor, and we asked this dude, if you had been hired by the international conglomerate the day before this happened, relative to this, what would you have told them to do? Well, he'd have said, I'd have told them to get a permit, because that's required by law, and they didn't. I'd have told them to either pave the thing and make it a ramp, or I would have told them to put in lights and signage and all this stuff. Well, how long would it have taken you to do that? I'm talking about fixing physically the aisle here. A day, maybe 2. How many crew members? 2. And what kind of hourly rate are you talking? And what kind of materials did you need? So wait a minute, for $800, they could have prevented this? And then what's the cross? There is no cross, right? You're smarter than that? No, I'm as stupid as your client. You can't do anything about it. It was unassailable. It was phenomenal. That's the kind of stuff that will get jurors pissed off. When we talk about framing things, and I said the binary, door number 1's bad, door number 2 is worse, characterize the defendant's behavior as a series of choices. You chose not to do X. You chose not to do Y. And they push back. You had discretion, isn't that correct? Physically, you could have done it, isn't that correct? They have to eat it, no matter how much they seek to dodge it, right? You could have physically done it. You had authority to order it. True? There was no rule prohibiting you from doing it. It would have cost next to nothing. Yes? You could have done it in 5 minutes, right? Cross-ray causation. Assert medical truisms. When we talk with Dr. Busfield towards the end, I'm going to cue him up for a while, and he's going to talk about his practice, but we're going to do a little bit of a mock exam, and we'll walk through some of this stuff. So, on causation, when you're dealing with medical doctors, are jurors going to disagree with these things and believe the defense if they say it? Doc, isn't it true that the greater the force, the greater the likelihood of injury? No, that's not true. Did the laws of physics cease to operate in your kitchen? Wasn't that my cousin Vinny? It doesn't? So that desiccated 80-year-old spine, wasn't it more likely that they would be injured than a 20-year-old? Come on, are they going to deny that? Then, as the forces increase, any resulting injury worsens. Simple. You going to deny that? more likely to be injured as we get older, takes longer to recover. The last one is Occam's razor. Are you guys familiar with this? I use this repeatedly. It doesn't matter what the term is that you use. People may say they're not familiar with it. It's articulated a handful of different ways. The simplest answer is the right one. A single explanation explains everything. As a doctor, when you're making a differential diagnosis, isn't it true that you are trained to assume that a single medical condition explains all of their presenting symptoms? What are the odds someone is simultaneously going to have multiple medical conditions for which they seek medical treatment on the same day, outside of trauma? On the same day I developed gout and congestive heart failure, now maybe some cardiologists are going to say, yeah, because your diet for 30 years caused both of them. Okay, so we pick something different, right? I got a bunion and, CHF. They don't fit. Whatever it is. So Occam's razor is the idea that a single answer explains everything. And I use this often in cases where defense causation experts want to come up with insane, crazy explanations. It's easy to attack them with this principle, and you can use the differential diagnosis methodology. I do a lot of birth injury cases, and when a child is born, okay, they can't talk. When you go to the doctor, what's the first thing the doc says? Why are you here? What's going on? The child can't say anything. They know the child's in distress, and it's a race, because they got to figure out the problem, because the problem is going to drive the treatment. So simultaneously, they are looking for bacterial infection, viral infection, hematologic disorder, chromosomal abnormality, and the one I'm always talking about is hypoxemia, perinatal asphyxia, not enough oxygen in the window right before delivery. What comes with that? Okay, so the blood draws come back quickly. There's no bacterial infection. There's no indication of a viral infection. The hematologic stuff gets ruled out. The chromosomal stuff is down the road. But also, as a result of being deprived of oxygen, the fetus shunts oxygen away from non-essential organs to protect the heart and the brain. Consequently, you'll have bowel ischemia. You'll have nucleated red blood cells, which are premature red blood cells being thrown out in extremis to try to aid in oxygen delivery to the brain. You will see these things as a cascade and they come together, and the single explanation is perinatal asphyxia. Then you go back to the strip and you show the delay, you show the cord gas, the metabolic acidosis. Every one of us right now, because we're alive and we're metabolizing, our pH in our blood is somewhere between 7.25 and 7.4-ish, let's say. Well, if we pinch off oxygen, it's going to go down. Eventually, it's low enough, it's going to cause brain damage. And that all fits together ultimately. This stuff's kind of heady. I'm sorry if I'm geeking out a little bit. We'll get back into sort of more mainstream stuff. Okay, cross-ray damages. Examine the position of a patient sees and treated with plaintiff's claimed injury. I'm a huge fan of this. Doc, let me understand this. You think I'm an idiot, right? And my client, he's like malingering, or he's got somatoform disorder, or whatever the problem is. You're an expert. You know everything. And this condition, this chronic cervical spondylotic myelopathy, you know it, you treat it, you know everything about it. Isn't that correct? You can fix it, you can diagnose it, you can care for it. Right? So, let's just indulge that I'm not an idiot and my client isn't a liar. Tell the jury how bad it sucks to have that condition. And when you set the trap up this way, they will defend till the end of the earth that they know everything. And after they've said they know everything, you ask them, how bad is it? And often they don't see it coming. Right? Here you see the left hand. It's not that hard. But this is something that you can do not just with doctors. It's kind of with any expert. All right. So, isn't it true it's a painful condition, it's debilitating and impairs sleep, and then have them admit.
You're the expert on this, okay? You're the evidence, you've been the prosecutor, the whole thing, you know the evidence code.
is there any issue with hypothetical is not an evidence, any of this stuff when you say assume this, assume that, and then tell us how bad it is? Isn't there some evidentiary objection that defense counsel could make to say he's not going to testify to what you just asked him to tell him how bad it is because there's no premise that it's that bad? You see what I'm saying?
Few things. So conceivably, there could be. Generally, I lay the foundation with them that they know it in advance. So I attack them early on that they're not actually qualified as an expert on these topics. So once they say, I know everything about hypoxic ischemic encephalopathy, right? Brain damage from a lack of blood flow and oxygen, okay? That's the injury that we claim the child has that causes cerebral palsy and all these other devastating issues. Well, how do you know this, right? What treatises do you rely on? What were you trained up on? What was the literature that you used? Do you use up to date? It's like Google for doctors. What was the textbook that you were trained on? Do you still own it? Whatever it might be. And they have to be qualified. So generally what they will do is they'll kind of narrow the fight, right? They may say it's bad, but your client doesn't have it. Or your client has a mild form. You can narrow the battleground. The other thing is that some of the things are readily understood and acknowledged by jurors when it's not crazy sophisticated, and or you can get it from a treater or one of your own witnesses. So you do need to lay a foundation at times relative to hypotheticals, but generally, right, it's a curative instruction. If you don't prove up the assumption, the question and answer are no good.
Then you ask them to strike what they could ask to strike what was done.
Right. And a curative
You make
instruction.
an offer proof.
Okay.
My witness hasn't testified yet, but Judge, believe me, that there will be testimony regarding this. Now, Doctor, we answer this question for me.
So he talks about how bad it is, as if it was, as established if it was there.
Correct. But generally, right, they won't debate the condition. Okay, so chronic regional pain syndrome. I first saw one of these, I think 98, 99. It was devastating and funky. I don't know if you guys know much about this, but it's a weird neurologic disorder. It's poorly understood in some regards. It is horribly debilitating. A lot of these people will actually commit suicide. You can cut the limb off that's affected and the pain doesn't go away. It's, what is it, sympathetic or parasympathetic? Okay, so it's the sympathetic nervous system basically gets out of whack. And a buddy of mine, when I was learning this, kind of like the second or third case that I had, remember Pong, the old game on TV, and the line would be burned on the TV if you left it on too long? That's basically what it is. The signal is continuing to run in the brain. And the only way to stop this really early on is they use ketamine injections, and they're not tremendously efficacious, but when I have clients telling me they start to light up with these symptoms, I say run to your doc and plead for this treatment. So in the 90s, into the early aughts, it was debated, but there are some funky hallmark symptoms. Blotchy, cold skin. I had a woman, her thigh skin temperature was like 73 degrees. We all know it's supposed to be around 98.6, okay? You would have mottling, you may have alopecia, your fingernails will be different, so there are a great number of hallmark, telltale physiologic signs that just aren't subject to debate any longer. But early on, it was an issue. Think about some of the things now. I mean, we're still fighting Roundup. And whether or not, what is it, glycophosphates are cancerous? I mean, they made the damn studies. They paid for them that they used, and they lost a bunch, but the tables have turned, and they're now winning. It's crazy. So this stuff at times is subject to debate, but I'm reasonably skilled at narrowing the field. And the ones that are crazy out there, hopefully I'm smart enough not to get involved because it costs a lot of money to lose. All right. Structure of cross outline. Primacy and recency. This is the idea that people remember what you start with and end, and it gives you the opportunity to, you know, if you're going to use 8 points on cross, rank them 1 through 8. So if number 1 point is your best, that's the first thing you're going to start with, and number 2 is going to be the 8th. Number 3 is gonna be the 2nd, number 4 is gonna be the 7th. Because you want maximum benefit and bang for the buck. You want retention on this. Impeach early, I already touched upon this, because now they'll lay over, they're terrified of being impeached again. Educate the witness, you'll ask, I already said this stuff, establish momentum, use headings. This is something I do. Invariably, jurors are gonna have some things they're interested in hearing about, and they're not gonna pay attention. So some of you right now are maybe, your attention is waning, maybe you're making notes, looking at an email, whatever it is, but there are some things you might wanna hear from me and you're gonna be more attuned. Jurors are the same way. So tell them, Doc, let's talk about X now. So hopefully the person on the jury that cares about X is gonna pipe up. I tell the jurors early on in opening statement, that pad of paper and pencil the judge put there on your chair, that's not a problem. It's to take notes, write this stuff down. And sure enough, they're writing the stuff down. And I tell them over and over, I use Busher block, I use all kinds of things. We are told, we know you have to imprint it into their brain. Have to make it simple so they will retain it with their existing mental constructs. Looping. This is something that I started doing as a prosecutor. I've heard other people talk about it. There's actually some judges that have rules. I've never seen a case saying this, but I've seen some like super local rules for saying it's prohibited. So here it is. Didn't you do X? Yes. After you did X, after you did X, after you do X. So I continually to reincorporate the affirmative information they provided in the response in case some moron on the jury wasn't paying attention and missed it. Okay? Judge, did you ever stop people from doing that? Did you see that done much?
I did myself as a prosecutor, why would I stop this?
All right. Well, here comes some of the big ones that are kind of crazy. Circle back if necessary. So when I was a prosecutor, I was trying all these cases, you had no impeachment. You had no interviews, no depositions. When I was a misdemeanor attorney, and particularly when I was doing low-level felonies, we had so many cases, we had no time to prep. I was doing closing argument. I'd have somebody down the hall picking a jury. I'd go tag out, they'd leave. I would have to read the file at lunch to do my opening because I hadn't even read it yet. I got up an opening, that's Officer Johnson. No, I apologize. That was yesterday's case. It's Officer Smith today. But the jurors loved it because in time, my sincerity and knowledge really couldn't be questioned. Tried another case in front of this old school judge, former federal judge, former federal practitioner, apologize. And so he asked me at the beginning, did this case get any press? I said, I don't think so. He said, well, where did it happen? I said, on the east side. We asked another question. I said, Your Honor, after lunch, I promise I'll have read the file and I'll be able to answer any of your questions. So I had no qualms about telling the jury. In fact, I wanted them to know that I hadn't read the file. Because when I got up in opening, right after lunch, it was nails, and I knew it was going to be, so it wasn't a problem. I was trying a case in Contra Costa County. This is a big war over turf for sales of heroin in North Richmond. My client allegedly was a member of a gang. There was another guy that was allegedly a member of a gang, co-defendant, and the prosecutor was putting on a witness, and I knew the guy was only going to testify against the defendant, co-defendant. I do the crossword puzzles all the time, the Chronicle, remember there'd be 2 of them, so I bring it in that day. And I sit there with the newspaper in my lap, and I'm doing the crossword puzzle. And I want the jurors to see, right, that I'm not paying attention because I know I'm not asking any questions of this person. I want them to know I don't care. There's some spat between the lawyers. We go into chambers, and I'm in the back because I'm not involved in this fight. And I got the newspaper there, and the prosecutor says, makes some snide comment about that. I said, well, look, if you put on another waste of my time witness, I can do the other crossword puzzle on the other side. And I walk out, I'm going to the room, and I'm holding the crossword puzzle here for the jury. Okay, so the circle back if necessary is this. When you try these cases and you don't have any cross-examination, you don't have an impeachment vehicle, you want to establish point on cross, right? But you gotta get there. It's gonna take you 15 questions, and you gotta chop off all the outs. Well, if at question 11 or 10, the witness thinks of an out you hadn't contemplated in this line of cross, so you don't have the trap, move on. Now you come back to it, okay? You don't start at number 1, you start at number 8, because 11 was the problem. But now you've cured the problem, the curveball they threw at you at 11, and you still can get to 15 and get to where you need to be. I did that a few times. Hasn't happened a lot in civil cases, but it is there occasionally. Okay, diminishing returns. Recognize that if you're crushing the person, feel this vibe. If you've got 8 points on cross, the first 3 are amazing. Maybe skip 4 through 7 and go to 8. Maybe just stop altogether, right? You've gotta have a sense of what is going on. Gotta meet the burden of proof, but beyond that, right, brevity is powerful. No questions of a witness, that's powerful. That's tough to do when it's an expert, right? Because the defense is gonna say, hey, uncontroverted. But you're gonna say, they can tell you the earth is flat all day long, it doesn't make it so, okay? Sun's gonna rise in the east tomorrow, people. I mean, there are ways to do it, and you should be open to them. All right, open-ended questions. This is high risk, high reward on cross. Who has done this? Okay, I've been doing this since I was a prosecutor. When I was a student litigator at the San Francisco Juvenile DA's office, this was in 92 or 93, I saw a guy do this. I was like, damn, that was crazy, right? Because nobody had told me that in law school, and I was still in law school. Well, I've been doing this for a while, and there are a number of people now that espouse this as a theory, but generally this is, you know, some next level stuff. You're not going to be doing this in your first few trials. But I told you about primacy and recency. Put it in the middle. If you fall on your face, hey, maybe they won't remember, and you're going to end strong anyways. So this is tremendous. The risk can be offset by thorough deposition. They use it in the middle of the cross so you can recover still. And, oops. All right, the other thing I was going to say on the high risk, high reward thing. I do a fair number of medical malpractice cases. When we defended doctors, we would have a partner that didn't work the case cross-examine the doctor on video. Did you guys see The Verdict? Right? Remember that movie? Doc, the answers have to be faster. I brought all my experience to bear. I don't even remember the old white-haired dude's name. He was a famous actor, right? But that's how they prime them to testify. Okay? So you have to be cognizant of this dynamic, and you have to think up stuff that they might not have thought of, because they're going to go in with a script. And once you get them off that script, it's powerful. Okay? When I'm in deposition and I find out a witness's tell, a lot of times I'll mock them once I know I own them. And I'll literally tell them, you've done that 5 times. And you may not do it again now because I'm telling you, but I own you anyways. I'm going to bring you up every single time. So they'll come in with a sort of stock answer or a pattern. And when you identify it, it's powerful to confront the witness with it.
What kind of responses do you get from their counsel at this point?
Off the record, or maybe they tell me I'm obnoxious, who knows? I mean, I've done a lot of different things. I've told people, I've got no more questions, but I'm not going to say no more questions because they can leave. And I say off the record a second. And I say, look, Mr. Smith, you need to know not to protect you from me, but to protect you from the guy sitting next to you who's being paid by Allstate that doesn't give a shit about you. Okay? And those people threatened to take a swing at me and things of that nature. But I did have a guy in San Jose one time let me do this in a case where he had CUNYs, and he gave me free rein. I did it to a guy in a case Nationwide was defending. His lawyer said, let's go, we don't have to listen to this? He said, no, I want to hear this. And she sat back down. They fired her, he got a new lawyer, he had to pay out of pocket over the top of it. I don't recommend this often. The same case I mentioned where the guy was from Bally's, his wife was a passenger in the car. She hadn't been deposed yet. So after we subbed in, I deposed her. We wrote a letter. She actually had 2 lawyers show up for the deposition. It was the insurance person from whatever it was, and then they picked up somebody from Stratman's office. And I said, you know, again, I didn't say no more questions. I said, off the record a second. And I said, ma'am, I have a letter here for you. There's a copy for your lawyers here as well, and it tells you that you're underinsured. And it says that this case is reasonably valued at $5 million, you only have $1.25 million, and they may tell you that I can't prove this, and they've hired experts that are presumably going to contest a lot of these things, but if you ask them if I can prove this, if it's worth $5 million, if they don't tell you yes, they've got a problem. I thought it would take 24 hours. It took about 72. We got a call from a coverage lawyer up the peninsula. We tried to play nice. The case still went to trial. We took second place, so that wasn't getting too good. It was a wreck in Tahoe around Thanksgiving, and this guy had sort of veered into my client's lane. Case should have been tried up there. Okay? No way would those people up in Tahoe have believed his bullshit answer. But our client was a spacey flight attendant from like Argentina or Brazil that had a brain injury, and she was really flaky, and so we lost. But that was an interesting question on venue, because I didn't control where the case was filed. But I want to win first. So in a case like that, again, I would have gone to where the incident happened, because the locals never would have believed his bullshit explanation for what happened with the little boy. All right, continuing on with this trial cross. You have your prepared questions because you're going to prepare for cross. You have follow-up to unexpected answers to your question, because invariably the defendant is going to say something weird and screwy, and it's imperative that you listen and capitalize. And then it's follow-up to questions of your adversary, because they're going to do redirect, or they're going to do direct if you call them on 776. And again, back to like I said, you know, you're going to come up with more ideas, hit them with everything you have under the sun. There are still more crumbs out there on cross. Okay, cross-examination of experts. You can cross-examine experts regarding contents of publication if it's relied upon in formation of opinions. If the publication is in evidence, it's never happened in my career, I don't believe there's any way to do that. Or if the publication is established as reliable authority by admissible evidence, which includes your own expert. So, Mr. Expert on my side, what's the reliable authority you could feed me on these propositions? Now, you can just read it. The document itself doesn't come into evidence. Different trial in Contra Costa County I was doing, rather noted sort of expert of easy virtue, out of Stanford, central casting, handsome dude, just willing to say pretty much anything, so kind of a problem, was on the stand, and I had a nice impeachment vehicle for him, this literature. And it was diffuse axonal injury, so your brain, gray and white matter, at that junction, they are different densities. So coup contra coup, with the movement, okay, here, and now the different density, can you see my fist? Okay, and then the recoil, so it rips.
Cheers.
And this right here, diffuse axonal injury, the axons moving between this are shorn, is a devastating injury. Like all tissue, it has to be vascularized to be alive. So immediately adjacent to that axon is a microcapillary. And guess what has a higher threshold for injury? It's the axon. So when the axon is shorn, the capillary is shorn, and when the microbleed is in the brain, it will resorb. What remains behind is the iron in the blood. And you develop what is called hemosiderin staining. And then you do the right MRI sequence, and the hemosiderin, the iron, blooms. It appears huge, even though it's microscopic. It's relative, of course. And then you can see it at this gray and white matter junction on the periphery on the study. Now, for those of you that do MRIs or know this stuff, CT scans, they do it from the top of your head to your brainstem. And then they shoot planes through this in parallel lines, and it's all laid out in the parameters of this. So maybe it's 5 millimeters apart. So if you shoot 2 planes through the brain here, you could have a massive blood patch, and you miss it. So when you actually hit one of these dots, it's the tip of the iceberg. You don't know. It could extend to a micrometer above and below the next plane going through there. Huge, huge, devastating, powerful injury. So to this point here with this particular doctor, we had this literature. And for spine, we tend to use primates because they're very similar to humans for study purposes. For birth injury cases and perinatal asphyxia, for whatever reason, we use sheep. So we tortured a bunch of sheep, and we would clamp their umbilical cords for a long period of time and then test their blood and figure it all out, and we extrapolated to humans. For brain injury, we use swine. Don't know why, but we do. So they took a bunch of pigs, and half of them they just cracked them in the head and neck with a hammer, and the other half of them they stuck them basically in a paint shaker. Okay? So, which one had more loss of consciousness? Turned out it was the ones getting cracked in the head with the hammer. But which ones had more diffuse axonal injury? It was the ones in the paint shaker. So this was an epiphany for people studying this stuff. And it was so devastating. So on cross-examination, I had this doctor up there, and I just said, "Doctor, here's the study. Doesn't it say on page 7, line 3 to 8, da-da-da-da-da-da-da? Yes. Doesn't it say da-da-da? Yes. Doesn't it say da-da-da? Well, this guy's a horse, so he couldn't help himself. He starts arguing with me. The judge just, no, doctor, it doesn't work that way. You were just asked if it's said down on the piece of paper. You just have to say what it says, yes or no. So this goes on for a bit. Well, then, this is really fun. This is lucky, but it was good too. So he sees kind of what's happening, and he's trying to read ahead because he's never seen the study before, and he finds something. And so he tries to jab me back. I said, "So doctor, you were reading ahead, weren't you?" "Yeah." "But you couldn't read fast enough, right?" "What do you mean?" "Well, because if you turn to page 6, it says what you said was disproven in the same study. It was a theory, but they rejected it." Okay, so the streamers were falling from the ceiling and everything. Those are rare Perry Mason moments. Okay. All right, so I said by admission, this is if the defense expert admits it, or another expert, your own, or judicial notice. And again, I don't know of any time that that's going to happen. But CDC, NIH, Cleveland Clinic, these are really not subject to debate amongst any person you hope would actually be on a jury. All right, so thank you. That is on the cross piece. So let me ask a second.
Can I
Any
ask a quick
questions?
question? Yeah, I was going to say, can I ask a quick question?
You absolutely may.
So I do all mediations now, so I'm just curious how it is with the trial courts. Are the judges giving you much latitude to do cross-exam, or are some of them trying to confine you to, you only get 30 minutes for cross or something?
So I am a state court practitioner, and I have not encountered a problem with a judge limiting my time to cross-examine people.
Mm-hmm.
You hear a lot of that in federal court. You do hear some people where they will try to give you time limits for your case in chief, okay? but not a witness per se. So you got to pick and choose. And then I always tell the judge in these things, because generally they want to say, what's 50-50? I have the burden of proof. So I have to do and say way more. I'm going to call 20 witnesses. They're going to call 4. And when we get to things like closing, I have to talk about jury instructions and the verdict form, and I've got to talk about damages, and all they're going to talk about is liability, or they're going to gloss over it. So the ratio really has to be 65-35, and if I get 55-45, I'm ahead of the game. But I haven't faced that as a problem per se. Anybody super good with this? Why isn't this working? Do you know?
That's where they're
This.
yeah, over.
But why isn't it coming up on here?
That should come up right there.
Here?
Yeah, it should. It's connected. No. It's not transmitting.
I don't know if that view's coming back. All right.
Oh, that's like,
We're gonna then sort of do this one with me talking as opposed to putting the slides up. So, I deal with a great number of complex medical cases. And all of you here speak English, all of you here speak law, all of you here speak your particular niche, okay? It's the same thing when you're going to talk about medicine. You have to learn this language. You have to learn anatomy. You have to learn physiology. You have to know medicine. And you have to know the root words. And once you do, it becomes super simple. So I already threw this out earlier. I talked about hypoxic ischemic encephalopathy. What the hell does that mean? My God, I get sick, crazy, nasty. Nobody's going to remember. Okay? Hypo is low. Hyper is high. A is none, not. So anoxia, worse than hypoxia. Hypercholesterolemia, high fat in your blood, okay? Traumatic encephalopathy, okay? Head, pathy is bad. Everybody knows what trauma is. You can extrapolate from all these things. Now, when we are talking to jurors, you're invariably going to have some sophisticated jurors and some idiots that couldn't get out of jury duty. Well, you have to communicate with all of them, and you want to engage all of them. So I seek to toggle back and forth, because the leaders and the sophisticated people, they geek out and want to know the real terms, okay? So I'll talk about traumatic encephalopathy, and then at other times I'll talk about just regular brain damage. And you also want to make the expert. Okay,
that's all.
I don't know what I'm doing wrong there. The first PowerPoint showed.
Go ahead, I'll just
Sure.
troubleshoot you.
So toggling back and forth ensures you engage everybody here. And you can have the defense expert agree with you that the dumbed down version that you're asserting is apt. So now it's coming from the defense witness as opposed to me, the lying scumbag ambulance chasing plaintiff attorney, okay? When the defense is admitting it and saying it, it's gospel for us. So doctors have to get informed consent for procedures. So this is an easy way. You asked about, like, how can you manipulate these docs and get them to concede these things? Doc, you do this surgery, isn't that right? Yeah, I do. Well, you have to get informed consent for the surgery, don't you? Yes. Don't you tell the person there's a risk of death from this procedure? I do. Don't you tell them that if something goes wrong, one leg might be shorter than the other, or they might have chronic pain, or they might need a future replacement? Okay? Now, you have to get informed consent from all of your patients, isn't that right? You don't discriminate in your practice, do you? So you see some really smart people, and you see some idiots. You see some old people, some young people, people with a tiny vocabulary, people with English as a second language. You have to explain this to a moron if that's your patient, right? So let's say you were going to say it to a moron, like let's say maybe a plaintiff attorney that had the audacity to sue you. How would you explain it to them to get informed consent? That's what I use against you at trial, and I play an opening statement to have you say it and dumb it down so the dumbest juror gets it, right? And
That's it. That's great.
Yes, sir. So you get this in a video deposition and then you play that at your opening statement?
correct. And a couple things I'm gonna do at the end is opening statement and sort of like a theory for presentation of openings.
Very good.
Thank you very much.
You're very welcome.
How are we doing on time here?
Thanks very much.
Hi. We're gonna skip ahead real quick because we gotta get to Dr. Busfield's piece. And
Same thing.
so let me tell you,
Just a real quick question. When you do an opening statement, how much of the deposition you show?
it varies and depends, okay? So a lot of people will tell you an opening statement shouldn't be more than half hour, 45 minutes, whatever the retention purportedly is of people and stuff like that. I did an opening statement, it was 3.5 hours, okay? Everybody would tell you that is wrong and you're gonna lose. It was the exact opposite, the trial was over. We put on the whole case in the opening statement, we had already won, and everything else was just self-fulfilling prophecy thereafter.
I'm just curious, which county, which judge let you do 3.5 hours of opening?
It was Contra Costa County and it was Judge Austin.
Ah,
So this is the, one I want to do. How do you make it huge?
So when you do that, do you skip over the admonitions, stuff that's kind of,
Oh, absolutely. Oh, you only take the meat.
judge allowed.
okay.
Yeah, yeah. So, I'll do this part real quick. So, for birth injuries, this is a paradigm for prosecution of institutional cases. I submit this is an integration of ball-on damages, rules of the road, reptile. You can do this with anything. I specialize in birth injuries, hospitals, labor and delivery units. But you can do this in an employment case, you can do this in an excessive force case, whatever it is. You have to understand the entity that you are suing, how they work, how they operate, and then use it against them. So in a labor and delivery department, what is the goal? It's to deliver without injury to the mother and fetus or fetuses. How do they do it? They have a team, there's division of labor, and they have a resource to identify potential emergencies. It's called a fetal monitor, and they're all trained up as to how it works, and they know how the pattern shows when things are going off the rails, and they know what's coming if they screw it up. So how do we win cases? How do we do it? We get the jury pissed off that they knew the outcome of their decisions and they allowed it to happen anyways. So we have the labor and delivery nurse say that, yeah, the fetal monitor is the way we figured it out, and if it looks this way, it means bad stuff. I tell them that in opening, then I push the button, and Nurse Smith says, everything Mr. Gatto just told you about that damn fetal monitor is totally correct, and it is an amazing thing. Then I have the doctor say, well, if we wait too long, it's going to cause brain damage. And then I have the doctor say that if this happens, they'll have CP, they won't live independently, all the stuff in my life care plan. And then doesn't it seem pretty disingenuous that they knew all this stuff in advance and that's their training, but they hired a defense attorney and a bunch of whores to tell you it didn't happen here? That is the essence of this presentation. We're a little constrained for time. I appreciate all this. We're gonna queue up Dr. Busfield for a bit. I'm gonna put up his PowerPoint, hopefully. Let me try this. Okay, so let me tell you about Dr. Busfield while I'm queuing this up. I have worked with Dr. Busfield on a couple cases, not a lot, but he is an outstanding surgeon. He is an outstanding expert and clinician and teacher. So he has done very well. He is well revered, both by, practitioners in the medical community as well as the plaintiff community that I'm aware of. I do not know how he is regarded by the defense bar per se. Perhaps some of you mediators will know. a little bit about that from cases you have had where he has been involved. And that's my bio. Nope.
That's the least bit.
Here it is. No, damn. I apologize.
I'll start talking if you don't mind.
Go ahead.
My voice loud enough?
Yeah.
Fine.
Great. I took some notes during Mr. Gatto talk, and thank you for inviting me, by the way, and thank you for having me. I couldn't help but thinking law sounds like poker game during Mr. Gatto talk.
It is.
Yeah, I got that. So it's funny, I always liked law. I almost quit to become an MD, JD. Actually, it's my first few years of practice. I got into expert by research I did. And I did a really bad pain pump product liability case. Well, cases, it was a number of cases. That's how I got into this. And I find it very mentally challenging in a much different way than medicine. I always get asked when I do my depositions, I do a lot of cases, if I do my plaintiff versus defense load. And it's gotten more and more plaintiff as time goes on, probably 70-30. But nobody's ever asked me why. And it'd be interesting to tell you my answer. So the people who do defense as doctors, it's the same report over and over again with no foundation because they want to get paid. I see it's embarrassing to watch. And I write blistering reports. I don't hold back. And that's why I've been to court only, I've been to court 12 times out of all 100 cases I've done because I write a good report. So I think that the report, at least as a doctor, seems to be the helpful part of my job as an expert. The defense, there's always the same doctor. I see the same 7 doctors in the same report. And it always comes down to, I can summarize it for you. So-and-so had a contusion, that's the case right now, a knee contusion, and it should have resolved in 6 weeks. So-and-so had a spine sprain, should have resolved in 6 weeks. Made up, totally made up. What they've done is they've been handed a case, and they say the end point has to be, it's not the fault of the person, so I'm going to come up with an alternative. What am I going to say? There's not much to say. Oh, it's arthritis, or it was a contusion. It's always the same report. It has no basis. And when I do a review of a case, I'm very honest, and I'm not going to say those things. So I think defenses like my reports because they don't help them. Whereas if they listen to me and settled, we have less frivolous cases. So I give a very honest opinion. In fact, when I review cases, I don't usually even ask if you're the plaintiff or defense. I'll tell you my opinion, and if you like it, great. If you don't, so be it. So I try my best to be objective, and I find that plaintiff lawyers are more wanting objective than defense, is my answer. A lot of defense cases come from corporations. And I know that, I've seen that already. ExamWorks probably turns out a good 80% of the experts, at least for orthopedic cases. I used to do ExamWorks. I did a case, I'm very honest. The ExamWorks executive came up to me literally the next day of the meeting and said, I gave up too much. I never got another ExamWorks case again. And I'm like, well, you guys can have it. So there was some bias in the whole cottage industry of defense experts, unfortunately. Anyway, my talk. Thank you. So I'm from Benicia. I came back in 2009 to practice after my training. I do sports medicine as well as general orthopedics.
I think I'm gonna have to talk. Oh, it is working. Good. Go ahead.
Yeah, I kind of treat everything. I operate on everything but the back and neck. So I'm able to do the more complex cases. It's rare to have a single injury in a car accident, for example. I do malpractice as well. Part of it, this talk, is I want to explain some orthopedic terms. Looks like some of you are the right age group in this room to benefit from this talk. I'll be 60 in 10 years. All right. So you guys have all heard these terms, but you don't know what it is. So what is arthritis? Is there a bean there? Which one's the bean? Is there a pointer bean?
Oh, yeah. Sorry, there.
There it is. All right. So this is an arthroscopic picture. Okay. Imagine you're an ant crawling in a knee. And this is what it looks like. Okay. It's super magnified. So there's the femur. There's 2 parts to the femur. So the knee is quite large. We're looking at a very small part of it. Femur, tibia, that's the knee, and the meniscus. We've all heard of the meniscus, but I don't know what it is. So arthritis is when you lose this beautiful white ivory covering of the knee, and you get that. So all the cartilage is gone, now you got bone. So bone rubbing on bone hurts. So if you ever eat chicken, when you break it open, you'll see the kind of gray because it's cooked. A gray coating on the joint, it's actually white. That's what it looks like. The meniscus is an O-ring. There's two C's, and two C's make an O. It's an O-ring of the knee. If you get just the right force, car accident, well, I feel like to say car accidents don't cause meniscus tears. Of course they do. I heard that defense many, many times. A force, even a little twist, will tear that O-ring, especially if you're older. If you're older, maybe you have some mild arthritis, and you get an injury, that's a meniscus tear. What does the defense say? It's degenerative. I know, I'm like, really? You're going to try to say this patient had this tear already, and after the accident, they magically got pain. I mean, that's the defense things they put up. And I do defense work, but I'll never say those things. So that's what it looks like. Meniscus tear looks like a little tear in the O-ring, and it's an unstable flap, but much like a hangnail. I hate that analogy. Like a hangnail, real flap, it catches on things. You trim it out, it looks kind of funky. It's got a curve to it, but no longer catches. That's all meniscus surgery is. Very, very basic. X-ray. I want an MRI. Everybody thinks an MRI tells everything. So I'll get to it in a second. Here's an X-ray. It tells arthritis better than anything else. You see that joint space is gone. That's bone-on-bone arthritis. That joint space is half of that joint space. That's moderate arthritis. That's bone-on-bone arthritis. Okay? I have this talk with patients all the time, and some of them get mad at me. They never had pain before. I believe them. The medical record never shows any knee pain. They're 60 years old. Now they got horrible knee pain for 4 months, 5 months from the accident. And I say, you have arthritis. But it was there before the accident. Oh, no, it wasn't. They get mad at me. No, it wasn't. It was. I didn't say your pain was there. I said your arthritis was there. You can have arthritis without pain. I'm sure all of us in the room have arthritis. Some of the body doesn't hurt you at the moment. But one little bump, one little accident, it can be trivial. Fender bender with $3,000 damages, maybe all it takes to make that knee hurt for a long period of time. So that's what arthritis is.
You better reclaim this position.
What is an MRI? And again, that defense. I'm not going to pick out defense. I do defense work, but I'm very honest. The MRI is not perfect. Even when I do practice medicine, somebody has knee pain with a normal MRI. Insurance will not give me ability to do surgery. And then people say in a legal case, well, the MRI is normal. They don't say it. They're trying to say they're making it up. And I'm like, what is the perfection rate of MRI? It's 95%. It's not 100%. I have seen, I think the case I can do, a patient with a normal MRI looked in their huge meniscus tear. So again, if you don't look, you're not going to know. It sounds weird to say. You never offer surgery on a normal MRI unless somebody had pain for a long period of time. I'm never going to think a patient's making something up. I've done a lot of what's called diagnostic surgery, normal imaging, but persistent pain. You always find something. They're not making it up. That's the problem with defense. They think the MRI is the Bible, and it's not. So I just talked about here the accuracy of rotator cuff, a full thickness rotator cuff tear, which we'll get to shortly. That's 100%, will not be missed on an MRI. Partial tears can be missed all the time. Meniscus tears, it's 95%. It's pretty good. It's not saying it's bad, but it's not perfect. You can't say, as they always do, the MRI is normal. There's nothing to do here. That's not quite how it works. I did a case recently. The MRI showed a meniscus tear on the medial side. There's two sides. And the guy went to surgery and he found a lateral and a medial. So I just said, there's your evidence to the jury. The MRI is not perfect. The surgeon found two tears. And what does the defense guy say? Oh, it's degenerative. It was already there. And the same argument. Did the accident cause my arthritis? No. I tell the patient to their face when I see them, if I'm doing an IME or do a lean, it didn't cause. It caused your pain. There's a difference. And my job is to make your pain go away, put that bear that was in hibernation that's now angry back into hibernation. That's what we're trying to do with non-operative care. Why can't you just repeat the road? So I like to use analogies. So a normal knee in a 15-year-old looks like a brand new black street. Drive on that, feels great. A fun drive. Here's kind of the 40-year-old knee. A little bit of breakdown in the street, but it's not bad. Maybe a couple potholes. And then here's the bad arthritis patient, perhaps usually older, where you can't repave that, but you can replace it. That's what a knee replacement does, is to get rid of the bad road. Injections, you guys all, maybe some of you had steroid injections. They're very effective. I look at these analogies. It's like I'm a sniper and a tower taken out, we'll say Putin, instead of carpet bombing the whole country with drone strikes. It has almost no side effects. You can get a small amount, just the right spot. You take an oral pill, it covers your whole body, gets that one spot. That's why anti-inflammatories have side effects. your stomach, your kidneys, but it has to touch all those things to get to your knee. Knee injuries, meniscus tears, just trying to show there's that kind of parrot beak tear, we call it. That's called the bucket handle tear, a big flap, flips back and forth. Those are very common injuries in sports and in injuries in general. And then ACL is right in the center of your knee, you can rebuild it, called an ACL reconstruction. ACL is pretty unusual in a personal injury accident, in my opinion. Meniscus tears are very, very common. What is sports medicine? Sports medicine is using a scope. So what's a scope? There's a picture right there. It's called the arthroscope, arthroscopy. It looks like the size of a straw. It's pretty small. And those instruments the same shape. They're very, very small so that you can access the joint. To use my other analogy, because I've been doing this 18 years, I caught the very end of open surgery. I've never done an open rotator cuff in my life. Open means making a big incision. So the equivalent would be, I want to replace the flooring in this room. I'm going to gash open the ceiling, bring a crane in, drop in some guys and do the work, or I can come to the door, or I can make a window. That's the difference between arthroscopy and laser. What was injured? Where do you have pain? This is important to you. I'm going to digress here for 1 second. What patients say where their pain is not always accurate. So, for example, they'll say, I have neck pain. Okay, that's your shoulder. But they won't point. They'll just tell the lawyer or whoever, or the doctor, I have neck pain. The ER, even worse. Neck pain. They're not going to look at anything else. Trust me. They're not going to examine the shoulder, the knee. But again, I've seen a number of cases recently where everybody's heard of the electronic health record, EPIC, right? It's all templated. It's all, not all. A lot of it is cloned and made up. So I did a case recently. I looked at the ER, the orthopedic exam, moving all joints without pain, including fingers and toes. And it was like a shoulder injury. I'm like, do you really think the ER examined the toes? They did not examine the toes. It's a template. And this happens all the time. And I'll say it out loud, like, that's the template. There's no way they examined. Or I saw an orthopedic surgeon who kept seeing a patient for follow-up, but told me, with a lymph node exam. I know that doctor didn't do a lymph node exam, even probably once, but it's cloned because of EPIC. So EPIC was made to bill, okay? To bill. So you have all the check boxes, the highest little billing. So Sutter or Kaiser gets the most money. Well, Kaiser pays himself also. But Sutter gets the most money. That's what's made for. It's not made for accuracy of records. And the ER is the worst. The worst. And I do a lot of cases where they come in, the patient comes in and doesn't have shoulder treatment for 6 months. And the defense goes, well, they didn't have shoulder pain until 6 months. I said, how do you know that? Well, look at the medical record. That doesn't mean anything. I asked the patient. I'm not going to lie to you. They saw a pain management specialist and a spine doctor. No one looked at the shoulder. And then finally they started to realize the shoulder. You see me 6 months later, I make a rotator cuff diagnosis, I do surgery. It's causatively related, but at that point, because it's been butchered, the case, I have to go to court or go to arbitration, because you can't just settle that one. We're going to fight too hard to deny the accountability of the shoulder. So patient words aren't accurate. So I have another example. Where does shoulder pain hurt? Here. It does. Trust me. It doesn't always hurt here. So if I hear I get an MRI, I feel send me the MRI of the arm, like it's a shoulder problem. Or they'll say I have back pain, but it's the butt. That's a different diagnosis. Or it's actually the side of the hip. That's a hip. But they don't tell the lawyer and point, and lawyers don't know what to do. So whenever you go to pain management, they're on the back and neck. They don't care about anything else. They're not. If you see your neck hurts and you don't point, they're going to get that MRI. They're going to treat the MRI like this, not examine the patient. That happens a lot in medicine too. So it's a little more complicated than just the words they use. The other thing is the Kaiser problem list. I can't stand that. They use it all the time in court. Well, the problem list says they have knee pain. What does that mean? Who put it in there? When? As the patient says, I didn't knee pain in 10 years. Well, it's an active list, but no one's reviewing it. No one's checking. I lost there. There we go. I skipped a couple slides there. Yeah, here we go. So hip pain. So really the hip, the ball and socket is here. It's almost genital area pain. This is called bursitis. This is called SI joint back pain. It's not straightforward. Patient, they kind of come in and go, I have pain here. And then you have to look for it. Pain management will go, oh, that's radiculopathy. And they won't even look. I mean, medicine's very imperfect, and you don't have the right doctor looking for stuff. It's not going to be in the record, and therefore you can't use the record as a Bible. I have this argument quite a bit in cases. SI joint, if I ever heard of that joint, I see it probably in almost a third of patients I see for injury. They've already seen pain management. No one's ever said SI joint in the entire record for a year. I examine on just one spot, I give 2 exam maneuvers, SI joint. So that's one, that one's missed quite a bit. What is the SI joint? It's a sacroiliac joint. It's a pelvic joint that's about 2 inches down and over from your back that most doctors don't know about or ever heard of, and therefore won't look for it or diagnose it.
Is there movement of that joint?
4 degrees, it wiggles. So you get in a car accident, all the force goes up your leg, through your SI joint, and into your back. So that's the joint gets a lot of force in car accidents. So you get shoulder and neck pain. Neck pain, real neck pain, is here. So it can range your scapula, can go over the shoulder. You can have shoulder and neck at the same time. If you don't look for it, you're not going to see it. Right? Rotator cuff. I brought from my model, that's my car, unfortunately. What is the rotator cuff? It's that most people don't understand it. If you look at someone's contour of the shoulder, that's the deltoid muscle, right? It's the muscle you see over here. Underneath it is the rotator cuff. There are muscles that come from your scapula or your shoulder blade and grab on the humeral head. And the best way to describe it, if I take my cuffed shirt and I make a fist and I take off my shirt and it won't come, and I look down the tube of my shirt, that's what the rotator cuff looks like. It's a ball with a cuff tissue around it. That's what it looks like. That's commonly torn in accidents as well. There's a force across the arms in a car accident. It's called an eccentric force. If the muscle is contracted and the joint gets lengthened, it tears, using biceps. If I have my bicep engaged and a load as hard as I can, someone's 1,000 pounds on it, and it gets forced in extension while I'm bending it, it's going to turn that tendon. That's the eccentric force. So again, showing the open, gashing a hole in the roof versus doing little windows to get the shoulder. What is rotator cuff repair? You take your tendon that's torn and you sew it back down to the bone with plastic anchors. That's all we do. It's very, very simple.
With what kind of anchors? Plastic?
Plastic, yeah. Metal's not used anywhere. I've used metal my whole career. Metal was the early versions in the 80s.
How long does the plastic last?
Last forever. So they have bioabsorbable. I use the non-bioabsorbable because it can make cysts in the bone. Like they're in the bone, you never feel them. And when they fail, because rotator cuff tears do fail, the anchors never pull out. The tissue pulls out of the sutures. Yes, sir.
So if you have an MRI, like the knee,
Yep.
okay, do you ever show the MRI to the jury?
It's an excellent question. I've been asked that by many cases recently. I tell them why. No one understands what the hell you're looking at with an MRI. And you don't. And I go, oh, we paid the animation company and I look at it like the animation companies, it's not my doctor, you can tell. It's a bunch of extra stuff. So as you walk into court, I have a model and I explain it in layman's terms like I was doing.
Right, but do you put the actual image up?
I personally don't recommend it.
Explain it, or?
I don't recommend that. I've been asked by, and again, I'm not going to tell the lawyer what to do, but I'll tell them what I think and all the animation, but I just explain it. The O-ring, I can have models I can use that I walk up to the jury and then I get to gain their confidence and teaching them versus just doing a slide that they'll understand.
Right, because you don't know how to read them.
Exactly. No one can read an MRI. Nobody here can read an MRI.
It's a blur.
Yeah.
I'll agree with that.
You often hear it said that too many injections into the shoulder
Yeah.
will break down the tissue so that if and when you need surgery, it's not going to work. Sometimes people are, I need the surgery now,
Yeah.
and on the defense side, well, you can have more of these.
Yeah.
I mean, I've heard that in
So I was going to make a joke. There's no reason to operate, but I don't. No. Yeah, you can do as many injections as you want.
Yeah.
Like, for example, I have an older population in Antioch. They all think they're going to die when they have surgery. I mean that. And no one dies of surgery, by the way. Ever. Okay, ever. So they all think they're going to die. They don't want surgery. Hey, I'm not going to convince you. It's fine. I inject older people all the time, and nothing bad's going to happen. I put it in a previous slide. The 3 injection year rule is made up by old doctors with no evidence at all. If I could digress 1 second to my pain pump experience, which is a shocking story of orthopedics. Many companies sold these empty reservoirs that gave an injection through a tube into the joint you operated on once an hour for several days. Okay, sounds great. No one tested, of course. Everybody starts using them. They put in local anesthetic. Well, guess what happened? It kills cartilage in 20% of patients. So I have 18-year-old patients with bone-on-bone arthritis from an arthroscopic surgery. So I read this story like, oh my God, this is horrible. Okay, what's happening? And then there's ads on TV. The lawyers are coming in trying to help out. And then what does the companies do? They lie. They go, oh, that's not our fault. We didn't tell them what to put in it. the whole zigzag argument, right? We don't say what to put in it, just in paper, right? So then I got works. I did some pain pump research, but not in a different location, but in the shoulder. So they got me involved, and so I had the idea. I'm like, I'm going to go into the library. I'm going to look up the last 10 years of pain pump ads, and I photocopied them all, and they all say Marcaine. Well, I said, because they're lying. So that was a product liability got into. And the first one case I did, we won $7 million, and then after that, they started to lose. I don't really know why, because the science is pretty solid. And then the manufacturer said it's the doctor's fault. They chose, and they started to the doctors. I had to start defending doctors, because that's not really a reasonable argument to make against the doctor. So I got to get my introduction. So a lot of orthopedics, in my opinion, is not proven. It's kind of done. That's a good example. I never do anything new to a patient. I wait for the kind of the dust stuff. Any questions? Let me know.